questions I already have 3 or 4.
Oh, you do?
Yeah, so I
encourage you to take all the vacation
this
time.
guy shows up. He doesn't show up.
Oh, here we go. All right. Like I say, if you sound like you're really efficient, you can order it.
Here, well,
It's still expensive.
I call this meeting to order and welcome you all to tonight's forum for the Whitman County Superior Court Judge. This is a primary forum, and as you know, the top 2 vote getters will come through to the general election in November. Our 3 candidates are here because each of them wants your vote, and we want to hear what they have to say in answer to your questions. My name is Karen Kiesling, and I have belonged to the League of Women Voters of Pullman for the last 57 years. I have served on the state league and on the local league in every single position, and my love in this group is what we're doing tonight: candidate forums, voter registration, and civics in high school classes. So it's a delight for me to be here, and the forum is recorded, as you've heard, available on our website, lwvpullman.org, in a few days. We begin all our meetings in the League with our nonpartisan statement, which is, the League acts in support of or in opposition to selected governmental issues which its members have studied. It does not support or oppose candidates, factions, or political parties. League members as individuals are urged to work in the political party of their choice. To protect the League's nonpartisanship policy, guidelines regarding the political activities of the Board of Directors are reviewed frequently. The League of Women Voters of Pullman is fully committed to diversity, equity, and inclusion in principle and practice. These concepts are central to our current and future success in engaging all individuals, households, communities, and policymakers in creating a more perfect democracy. We acknowledge and honor the first people of the Palouse region and their descendants, including our neighbors, the Nez Perce, Colville, and Coeur d'Alenes. Before we begin, let's review how things are done. We ask that you write any questions for the candidates on the cards on your seat. You may ask as many questions as you want and can start writing now. When done, raise the card to be collected. League members seated at the front of the room sort the questions by topic. Duplicate or similar questions may be paraphrased and combined. They also ensure the questions are legible. To help out the moderator, please write as clearly as possible. We will get to as many questions as possible as time allows, and tonight with 3 candidates, I will tell you that is very restricted time. If we don't get to your question, I suggest you talk to the candidates after the forum. Please turn off or silence your cell phones and refrain from clapping or booing or any other disruptive behavior, throwing money, for instance. We will begin with opening remarks. Each candidate will have 3 minutes, and then we will go to the questions. We are going to start with our candidates speaking to you in alphabetical order by last name, so we start with Jenna Brozik.
All right, thank you very much. My name's Jenna Brozik. I'm one of the candidates running for Superior Court Judge. It's a nonpartisan position. As you know, the primary is August 6th and the election is November 5th. I'm the owner and managing attorney of Prince and Brozik Law Office in Pullman, next to the Old European Restaurant. I've lived in Pullman for the past 17 years. My husband and I have raised our twins here. They're going to be seniors next year in Pullman High School. I was a stay-at-home mom with my children until they were 2, and then I went to law school when they were 2, and I graduated when they were 5. So I went to the University of Idaho College of Law. I've been practicing law since 2010, so I'm also the pro tem judge in Colfax Municipal Court. I'm also an adjunct professor of law at the University of Idaho College of Law. Although I practice criminal law, the focus of my practice has been family law, custody, divorces, adoptions, probates, will contests, guardianships, protection orders, those kinds of civil disputes. My practice is the only one of the candidates here that directly mirrors the kinds of cases filed in Superior Court right now. I have supervised and mentored about 5 attorneys over the past years practicing civil and family law. My experience as a small business owner employer will translate well into running an efficient courtroom. My extensive experience in many areas of law that are in Superior Court and my background makes me, I feel, the most well-rounded candidate running and the best qualified for the position. I've been practicing, like I said, for 14 years, representing fathers, mothers, children, serving people in our community. I see the bench as a service position. It's serving you, serving the people of Whitman County. It's not a career opportunity. If I'm elected judge, my courtroom will be free of bias, favoritism, and politics. There's no room for that. So an independent, fair, and impartial judiciary is indispensable to our justice system. If people don't believe they're going to have a fair shot in court, then our system's broken. I'm going to make sure people get a fair shot in court. So my main goal, if I become elected, is to make sure everyone has a fair shot, everyone is treated with respect and fairness, everyone in Whitman County who appears in front of me receives the justice they deserve. So our legal system is based upon the principle that we have an independent, impartial, and competent judiciary with judges that have integrity. I have integrity, and I will assure these fundamental principles are abided by in Whitman County Superior Court if I'm elected. Excuse me. Later on, we'll go into civil cases versus criminal cases, but I have to say that the judge has extreme discretion in civil cases, and that is my main focus of law, and that's where I think it's really important that you have an attorney that's running for judge that is very well versed and experienced in civil law. Thank you.
Thank you. Steve Martonick?
Thank you, and thank you to the League for this opportunity to speak to you tonight. Who here remembers voting for Superior Court judge? And I'm not going to ask Judge Libby, but we just have 3 or 4 hands. Put hands up one more time, please. Okay, Evan. Who was the last election?
It was Dave Frazier and Dave Savage, 2002.
So 2002, 22 years ago. That's how often you get to vote for judge. So this is a rare opportunity for all of you. Why it doesn't happen more often, I don't know, but the judge in Washington State, the Superior Court judge, is elected. In many states, they appoint their judge by the governor, or they have a body, a committee that appoints judges. But you, at least occasionally, get the opportunity to vote for judge. And so that's why we're here tonight. And again, thank you to the League. So what's a Superior Court judge do? Right? And Judge Libby, you can't pipe in unless I ask you. What's a Superior Court judge do? Primarily, they're the court of general jurisdiction. Unlike Judge Hart's court here, they can hear any case. District court's limited by statute to certain cases they can hear, mostly misdemeanors, small claims actions, various things, but it's limited by statute. There's no limitation on the state Superior Court. It is the court of general jurisdiction. It's a constitutional court. And so it has equal standing with the other branches of government, the executive, the legislative. It stands in the same position. So it plays a very important role in our community. And as I suspect you're aware, there's only one judge for Whitman County. So what does the judge spend the time on? Well, mostly, and this is coming from the case loads of the courts of Washington. This is a website the Washington State courts maintain, Office of Administrative Courts maintain. It's where you can get information about your courts. In 2023, Whitman County heard 886 criminal matters. Those are hearings. Those are not filings. Those are hearings. It might be a suppression hearing. It might be a trial. It might be a probable cause determination. But those are the hearings in criminal court last year. So about 50% of the total caseload, 1,626 hearings, I should say, last year, 886 were criminal. But that doesn't include juvenile, which is additional 150 cases for juvenile criminal. So between juvenile and adult criminal actions, the Superior Court spends about 64%, 63% of its time on those matters. The other matters, I'm sure they get the attention, but they're not nearly as numerous. One other matter that is pretty numerous, it constitutes roughly 9%, is the juvenile dependencies. Dependencies where the state, is that 1 minute warning? Well-
Thank you. We will let you finish
All
your
right.
sentence if you wish.
Well, yes, so my finish is, the dependencies where the state wants to come in, take the child out of the home for protective reasons. So that's 9%. So altogether, criminal and dependency is about 73% of the caseload of the court.
Thank you. Roger Sandberg?
Thank you. Thank you again to the league for hosting this. Thank you all for attending. Thank you to the people on Zoom or watching the video later. I appreciate your interest in this. As the other candidates have said, it's a very important race, and it doesn't come along very often that we have to make this decision. A little bit about me. I was born in Moses Lake, Washington. I went to high school there, graduated, went to Whitworth College, then went to the University of Washington School of Law. And I came here in 2008 and have been an attorney, ever since. And so I have been doing every single type of case that is going to come before the court. I've been doing criminal law cases, a lot of criminal law cases, a lot of family law cases. We're going to apparently talk about case numbers and case loads and which is more numerous, criminal or civil. I will tell you, I'm comfortable doing either. I've done a lot of criminal cases, I've done a lot of family law cases, a lot of civil cases. Every case is important. It's not just criminal cases that are important, it's not just family law cases that are important, one or the other. I've done every type of case, and I've done a lot of them. I've been the managing attorney, a partner in the law firm of, started out as Esser and Sandberg, and then a few years ago it's Esser and Sandberg and Boyd, but I've been a partner there since June of 2009. I've been presiding over cases since 2010, when Judge Doug Robinson in District Court needed somebody to fill in. I've been presiding over his cases since 2010. In the last 5 years, I took on part of the public defense contract. Whitman County does not have a Office of Public Defense. They just contract with private attorneys, and so I've been taking on those cases for the last 5 years, in addition to doing all the other cases. I've got substantial experience doing every type of case. Every type of case is important, and yeah, I've seen every case from all the types of cases that are going to appear before the court, whether it's family law, whether it's guardianships, whether it's adoptions, dependencies, felony criminal cases, misdemeanor cases, everything. No contact orders. I've done all of those cases. Why am I running for judge? I'm running for judge because I care about the outcomes of the cases. And it's not about any career aspirations. It's really because I know the cases that I have for my clients are the most important cases in their lives, and it's no different when these people are appearing before the court. As an attorney, you're trying to advocate for one side or the other, but as a judge, you get to do what's right, and so that's why I'm running, is because I care about the outcome of these cases. Thank you.
Thank you. We will now get to the questions. You each have 2 minutes to answer, and we will start in reverse order. So Roger Sandberg gets the first question. Oh, I better take the microphone, I'm going to get in trouble. My salary will be cut, I'm afraid. So the first question is, an elected official in Whitman County wrote that the Superior Court judge needs the following qualities: knowledge, broad experience, common sense, and good judgment. Do you agree with these qualities being needed, and what would you add to the list?
Knowledge, experience, common sense, broad judgment, and whatever. I agree with those qualities. I would add empathy. I think having a good heart is very important for these cases. It's hard to not get emotional about some of these cases. I remember one of the first contested sentencings I had was back in 2011, and I still remember the names of the parties. This happened, there was a boy that died in Palouse under a bridge, and I'd done sentencings before that, but this was one of the more heated sentencings, in the sense that, a boy had died, a young girl was charged with a crime for essentially violating a court order for being in contact with him. She didn't cause the death, there was no allegation she caused the death, but it was a very contested sentencing in the sense that the defense attorney was asking for no time. This person just, all they did, their crime essentially was violating a no contact order, having some contact with a boy who eventually died from a drug overdose, and this is very traumatic for the community of Palouse, and a lot of emotions at play, including the parents of the boy who died were speaking at that sentencing. And I remember the boy's name, I remember the girl's name, 13 and a half years later, even though I never knew the boy before. And you just, I mean, you feel for these parents who've lost their kid 4 months later, and they're asking for this girl to be sentenced to the max you're allowed to sentence them to, and the defense attorney is saying that this girl didn't really do anything other than have contact with her friend. And so they're tough. I mean, these cases are going to stick with you a long time. I think you need to have a good heart. I think you need to just really care. And I do care about my clients. I care about the outcome of all these cases. So that's what I would add. Thank you.
That same question now for Jenna Brozik. Do you need the question reread to you, or are you comfortable?
Sure, that would be great.
Oh, I'm sorry, I misunderstood you. I'm sorry. An elected official in Whitman County wrote that the Superior Court judge needs the following qualities: knowledge, broad experience, common sense, good judgment. Do you agree with these qualities being needed, and what would you add to the list?
Excuse me. Yes, I agree. I would also add integrity, honesty, compassion, and accountability. And I think Roger did a good explanation of the compassion, but I also think that you need an understanding of how serious your decisions are going to be on people that come before you. For instance, I had a case where it was a divorce and it was a 50-50 parenting plan, and you know, the judge at the time ordered 50-50. The son of these two was about 5 years old at the time. The father had a substance abuse issue with marijuana and some other issues, but unfortunately we couldn't bring all of that evidence to the court. We brought most of it to the court, but what happened in that case is the judge ordered a 50-50. And then I ran into my client in the grocery store probably, 10 years later. Then her son is now 15. This was like a couple years ago. And I said, how's your son doing? He said, well, he's living with his dad, and he smokes pot all day, and he's dropped out of high school. And so you think back, I think back when we did the divorce, and I think back and I think, wow, things could have been a lot different if things went a different way. I think that I've, experienced a lot with my clients through Superior Court, where the decisions could have been a lot different and it could have been a different outcome. And so I think as the judge, you need to really realize how serious your decisions are going to affect people the rest of their lives. Thank you.
Thank you. Steve Martonick? Martonick, sorry.
That's fine, that's pretty close. All I would add to what Roger says is independence. A judge must be independent, make his own decisions, her decisions, whoever it is, but they must be independent of outside influence. And that's one reason I don't accept endorsements. It doesn't look well if you've got somebody practice in front of you who endorsed you as judge. Even though you don't call into question anybody's integrity, it doesn't look good to the public. I'll give you, for example, I used to go to lunch every Friday with the courthouse crew. We'd go downtown, go have lunch. And a client said to me one time, he says, oh, you guys just decide cases there at a lunch table, don't you? I said, no, that's ridiculous. Just, of course not. We might talk to a prosecutor, hey, when we get back to the office, let's go over this case. But we don't decide cases. But then I heard it again. You know what? That's not an irrational conclusion. It's not true, but it's not irrational. And so I stopped going to lunches because it gave the wrong impression to many people that, hey, we were settling cases outside the court not in the open, but in the closed. And so that's why I say independence is a critical element of a judge to make their own decisions independently and appear to be independent as well as be an independent fact.
Thank you. The next question, and we will start with Steve Martonick answering this one. It's about public defender service. Is it important? Why? Have you been one? And why not?
Why not? I can't answer the why not. Clearly, the cost of attorney is prohibitive for many, many people, and it's just an elemental function since Gideon versus Wainwright of our justice system. And it's not just criminal matters, but attorneys are appointed in many other matters. For example, dependencies I was talking about. Right. I used to have the pendency contract awarded by the Office of Public Defense. That's a state office. Locally, public defense is handled by the county. They bear the expenses, but on the dependencies, the state bore the expenses, and they retain me to take that on, that responsibility. And did that for several years and passed it off. It just got to be too much time consuming because, as I mentioned, it's 9% of the caseload, and so that's substantial. But I don't, Judge Hart, I mean, we did first appearances today, people were arrested over the weekend. He has a judge, he has an attorney there in the courtroom. I can meet with them on Zoom in a breakout privately. I try to meet with them beforehand. I can talk to them, walk them through the process. But I'm glad he insists on that procedure because I think it's extremely useful and it starts things off on the right footing. But you can't overstate the value of public defense. It's an absolute necessary for a functioning justice system.
Thank you, Roger Sandberg.
I think public defense experience is essential. I really do. And I've been doing public defense cases for the last 5 years, as I said, court-appointed cases, probably even before that on some conflict cases. But that's what you're going to be dealing with as a judge. I mean, there's so many cases that are coming before you, whether it's not just court-appointed cases in criminal matters, but just in family law matters. You're going to be dealing with people who are unrepresented by attorneys because attorneys are expensive. They're very expensive. And we don't have a lot of attorneys in Whitman County. That's another problem. But attorneys are extremely expensive. You're going to be hearing a lot of what we call unrepresented litigants, pro se people who do not have attorneys. It's one person against another. They're seeking a no contact order. They're seeking a divorce. You know, they want a parenting plan or something like that. And you've just got to have that experience with dealing with people who don't understand the legal system. You're not always going to be talking to lawyers. You have to explain things in simple terms. This is what you're doing as a public defender is you're taking somebody, there's a high volume of cases, you're just repeatedly explaining the process, the procedure to somebody over and over again and saying, this is how it works. As a judge, you got to do the same thing. You have to explain in simple terms how the procedure is going to work. At the beginning of a no contact order hearing or a family law hearing or a criminal first appearance, you need to explain the procedure because people need to know how this is going to work. And there you have to be cognizant of drawing a line between being too formalistic, too rigid in procedure versus trying to reach a decision on the merits of the case. Yes, there are procedural rules. There's rules that say you have to give the other party a certain amount of time. You don't want to just throw a case out for certain reasons if you're trying to reach a decision on the merits. So I think public defense service is essential. Thank you.
And Jenna?
So my public defense experience has been in dependencies. So I've represented parents, I've represented children in dependencies, parents whose rights are and subject to be terminated. I've done lots of trials in dependencies. So that's my public defender experience. And as far as my criminal experience, I've done criminal experience my whole career. DUIs, misdemeanors. I've supervised my attorneys that practice criminal law. I have a case right now in front of Judge Hart where I'm going to a jury trial. So as far as the criminal side, I do have the criminal experience. I don't think you need to be a public defender to become a judge. I think what you need to know is the kind of cases that are filed there. You need to have experience, being an attorney, being in Superior Court, knowing the law, knowing the rules of the court. And as far as self-represented clients, I have worked probably significantly more than the others on representing clients that could not afford an attorney. I've done a lot of pro bono cases where I actually wasn't paid. Yes, they represent indigent clients, but they're getting paid to do that. It's important. It's important that everybody has a chance. Everybody has an, I think it's important they have an attorney. And that's what helps our justice system. We need people that can't afford to have an attorney to have an attorney. And so a lot of the civil cases that I have done have been pro bono. I've represented clients for ATVP that they need an attorney. I've represented victims of domestic violence. And I think it's really important. When people don't have an attorney and the other side has an attorney, it becomes really unfair. And so as the judge, you have to make sure that the one that's not represented gets a fair shot. And as Roger says, you need to explain the system to them if they don't understand. But you cannot, as a judge, give them legal advice. So it's a fine line you have to cross. And you have to be really careful what you say to these to people that are self-represented. And I think it's a huge issue in Whitman County that we don't have enough attorneys doing pro bono.
Question number 3, and Jenna, this will come to you first. As is well known, defendants unable to afford an attorney in a criminal case are provided court-appointed attorneys through the Public Defenders Program. This is not true in civil cases. In civil legal cases, low-income people often face complex legal issues and court appearances without legal representation. In civil legal cases, have you provided volunteer pro bono services to low-income people to address fundamental needs such as the dissolution of marriage, child custody, housing, family security, and more? And I will remind our folks that they need to stay within the 2-minute time frame or we were going to have to cut them off. So please don't make us be in that position. Thank you, Jenna, for your answer to this question number 3.
Yes, and it kind of, I can piggyback on what I said before. So I've done a lot of pro bono. I've worked a lot for the community here, providing representation to people that could not afford attorneys. I've worked with the Moderate Means program in Spokane, where basically the students in Gonzaga contact me and they ask me, can you take on this case? They can only afford this amount. And so I've done that every year for the last 14 years. I've done the Moderate Means program. I've done represented clients that couldn't afford an attorney. Like I said before, I worked with Alternatives to Violence of the Palouse. I've worked closely with them for 14 years, and when they had clients that needed an attorney but couldn't afford it, I stepped in. So I think it's been very rewarding, and I'm glad that I could help these people. And I think that it's a real problem in Whitman County. We don't have enough attorneys that are doing pro bono. Thank you.
Thank you. Steve Martonick.
Just briefly, I really don't want to get into pro bono and free services for clients because I think it lacks humility. I mean, you do those things because it's the right thing to do, not so you can campaign on them or tout them to your friends or look at the good work I've done. So I mean, just I'm not comfortable addressing it.
Thank you.
Thank you. Yeah, I have done a lot of civil legal work representing people in civil situations as well as criminal situations. Ms. Eugene Seipel is here. Eugene was instrumental in the Whitman County Legal Services Program, of which I was a board member or something like that. We called ourselves, I don't know. But yeah, we've done a lot of pro bono work. The WSBA says that attorneys are supposed to do 50 hours per year of community service, and I would say I probably meet or exceed that every year. And as Steve said, I mean, it's just, there's so many things you do. You don't keep track of time. I've never kept track of pro bono hours. You just do it. So, I mean, I agree. It's a real problem. We need to get more. We need to get more attorneys doing it. There's a shortage of attorneys. There's just too many cases. There's just too many cases. I really wish I could. I don't know how, other than the judges that are here, it's just you come to court on any day where we're having a docket, and there are so many unrepresented people because they just can't afford an attorney. I get calls all the time, and I wish I could take more cases, but I can't. I have 36 cases this week in district court that I'm going to be covering. That doesn't include the people who were arrested this weekend. That doesn't include the people who will be arrested tonight and the remainder of this week. That doesn't include the docket that I'm going to cover. So there's just an overwhelming amount of cases. And so I wish I could do more, but yeah. So to answer the question, I've done plenty of community service in the civil situation.
Question 4 will begin with Roger, and the question is, do you support alternative or alternate courts for second chances, drug courts, and so forth?
I do. I'm currently a member of, so Whitman County District Court has a community court program. Judge Hart has got that started in the last 2 years or so. I've been a member of that since the start, a community court team member. And we call it community court because it's not limited to drug issues or mental health issues or veterans or whatever. We kind of just take everybody because we don't have, we have a lot of cases, but we don't have high enough volume to separate people into drug court versus mental health court versus veterans court like you see in King County or Spokane. So yes, I do support that. Superior Court also has a drug court, and the volume of that is down a little bit because possession of a controlled substance in Washington is now a gross misdemeanor. So most of those cases are going to district court, whereas they used to be in Superior Court. And so usually it was that possession of a controlled substance, a lot of those people would go into drug court in Superior Court. We don't have that volume now because they're gross misdemeanors. So I've also I was one of I represented one of the first admittees to Spokane's Veterans Court all the way back in 2010. This was an individual who was an honorable veteran, but just sort of had a PTSD incident where ended up sort of fighting with police officers, and they all agreed that this was sort of just an odd behavior and immediately calmed down after that. And so we admitted him, even though he was charged with felonies, we admitted him into Veterans Court in Superior Court in Spokane, and he was one of the first people to do that. He ended up deploying to Afghanistan with the judge who was the presiding judge of the Veterans Court and serving in his security detail. So he was a successful graduate.
Thank you. Jenna?
So I would agree that I think there should be alternate services for people that have drug issues. One of the things I've been talking to the police and the sheriff out in the community, and some of the problems that they have is that people get arrested and they have a drug issue, and then they serve time in jail, and then they go into treatment, and then they come back again because they get arrested again because they've done something like a burglary or some other offense, and they come back and they go through treatment again, and so it's a real problem. I think though that if someone comes to court and it's their first offense, or and if depending on the facts, if the as far as the drug court and services, as far as substance abuse treatment is appropriate, then they definitely should get treatment. I think treatment is the first option, and then we have to look into the facts and see, okay, how have they done in treatment, and are they going to go out and are they going to do something to the community again, as far as putting the community in danger. So it's a real balance act you have to make as a judge, and you have to look at the facts. But I do believe that treatment is a good option. Thank you.
And Steve?
I'm proud of what Whitman County has done regarding their community court, their drug court. They're excellent programs, so well run, And they're not get out of jail free cards. That's not what this is about. It's not just a way to escape responsibility. It's a way to address the issue that got you from the court to prevent recidivism, to get this taken care of, to address this time, so you're not back again. Right? If you mess up, if you just fail to comply, then you will get your sentence imposed. So I get these questions occasionally, you know, well, insanity, somebody asked me about, well, isn't an insanity plea just a get out of jail free card? No, no, you're going away until the board determines that you're safe to release back into society. You're going to a lockdown facility. It's not, you know, plead insanity and walk out of court and go home. It's rigorous controls over these systems, over these programs that I think can make them work, and they do seem to be working. You know, I haven't seen the numbers yet, how they're returning up, but it's common sense. Whether that makes good sense at the end of the day, you know, that's for the statisticians, for the experts to investigate. But it's intuitively, I think morally, it's the right thing to do. Give people a chance to address the issue which got them there. That's what our courts are doing. Like I said, I'm proud of them. I think they're doing a good job in that area. And hopefully it continues and does prove at the end of the day to be an effective method of addressing these issues and keeping people out of the courts.
Question number 5, and we will start with Steve. The question is, what is your stance on no-fault divorce?
I have no stance.
All right, we will move right along then to Roger.
I mean, it's the law of Washington, no-fault divorce, and I think it's a good law. I don't think the court should be examining who is at fault for the divorce and thereby determining, you know, we're going to award one spouse more property because they're not at fault for the divorce, or we're going to give this spouse more parenting time because they're not at fault for the divorce. The reality is, well, both people could be at fault. But even if they're truly not, it's just not something the court needs to get into. So that's how divorces work. When you're dividing property, you're dividing, you know, determining a parenting plan. You're not saying, oh, this party was bad, so I'm going to give him less property. Now, a party's behavior could come into play in a parenting plan, of course. I mean, if a person's got a drug addiction, alcohol addiction, if they're, you know, violent, all those things would come into play, but to examine who's at fault for the divorce is a good thing we don't get into.
Thank you. And Jenna?
So I would have to agree with Roger. I think it's a good law that we have in Washington, no-fault divorce. In Idaho, you can actually consider the fault of one of the spouses. So, for instance, for maintenance or something like that. But you know, as we know, it's a huge percentage of marriages that end in divorce, and there's all sorts of reasons why they end in divorce. And there is case law that says there's certain behavior the judge can consider in a divorce. For instance, if one of the spouses commits waste and has a gambling issue and, you know, has spent all this money on community assets or something like that, the judge can consider that. And you know, take those kind of facts to consider as far as dividing property. So yeah, I think it's a good rule that we've had. I've done divorces for all my career, and I don't think I would want that law to be changed. Thank you.
All right, the 6th question, and we will start with Jenna to answer this one. Given that many people feel courts move too slowly and legal costs are too high, what will you do to speed up outcomes and to reduce legal costs?
I think in Superior Court, one of the issues that I see as a civil practicing attorney there is when you file a case, you don't have a scheduling order. So when you file a case, I would change that, and I'd make a scheduling order that says, this is when discovery is due, this is when you know, this is when you should have mediation due, these kind of things. Right, I've seen cases where I've had a divorce where it was sitting in Superior Court for 5 or 6 years, and I was the second attorney that came along, and so these people need their cases to be resolved and get through the court system. I think that there needs to be a more efficient system. And as far as pushing those civil cases through, I know that I can make a huge impact by immediately doing a scheduling order, making sure that also, even maybe if there's time, conferences and seeing from the attorneys or the parties, what's going on here? Have you been to mediation? What, is there a trial date set? But a lot of cases that that I've seen will just sit there unless one of the attorneys does something. A lot of the times, self-represented people, they don't know what to do, and they just file something, and so it's something that I think I can make a huge impact on. Thank you.
Steve?
Would you repeat the question?
Yes. The question is, given that many people feel courts move too slowly and legal costs are too high, what will you do to speed up outcomes and to reduce legal costs?
Well, we're front-end loaded. I mean, Idaho, it seems that you have a dozen hearings and meetings mandatory before you come to a decision whether it's civil or criminal. I don't think adding more hearings, more scheduling is the answer. I'm not sure it's the problem it's perceived to be. If you looked at our caseload, Whitman County has one of the best turnover rates, as I recall. It's been a few years since I looked at it. I'm thinking back. But as far as case resolutions, especially in criminal matters, we were one of the top counties in the state. So I'm not sure it's the issue that some might suspect. Things actually move along, and you do need the attorneys to push it, clearly. I mean, nobody else can be driving unless the judge intervenes, but preferably, especially in civil matters, parties want to complete the discovery. They know where they're at with their case, and it's probably best left to them.
Thank you, Roger.
I agree with both. I mean, I don't know that in Whitman County our backlog is as bad as some other counties. Yeah, so as far as what we can do to speed things up, I don't know that I would enter a scheduling order at the beginning. I've had divorces that have gone for years as well, but the reality is the parties weren't sure they wanted to get divorced. They're reconciling, and then they're breaking up again. They get back together, they break up again. And that's just how some divorces go. It's not because they couldn't get a trial date. No case goes on for 5 or 6 years because they can't get a trial date. I mean, if you wanted to get a trial date, first of all, we have several rules that are already in place. There are rules regarding time frames for discovery. We have a mandatory mediation rule in Whitman County that says parties have to go to mediation to try to settle these things. And if we wanted to get a trial date in Whitman County for a divorce, a 1 or 2 day divorce right now, it'd probably be 3 or 4 months out. Okay. Now, the reality is family law matters are lower on the totem pole than in custody criminal cases or out of custody criminal cases, so they're going to get bumped if there's a conflict in terms of who's going to trial. But we're not that far out. Cases don't linger because we don't have the right rules in place. I agree. The attorneys just need to push the cases along. The attorneys know what the rules are regarding timeframes for getting discovery exchanged. And if you're going to set a temporary, if there's true conflict, you set a hearing, and hearing on temporary orders will be heard within 2 weeks. As far as what to do to reduce costs, that's a tough one. I mean, lawyers are expensive. There's not a lot of them in Whitman County, and so it's sort of a supply and demand thing. We can encourage more lawyers to do pro bono work. We do have this mandatory mediation. We also have in the courthouse a courthouse facilitator that can meet with parties for free. Well, I think they might charge a small fee if you're not low income. So we do have a courthouse facilitator that helps wrap up some cases. Thank you.
7th question, and we will begin with Roger on this one. Explain your thoughts about sentencing guidelines, especially regarding mental health and drug abuse. So in Superior Court, we have sentencing guidelines that determine what the range is that a person faces for a given felony. It depends on your criminal history. Of course, it depends on what you're charged with. There are sentencing alternatives that are available for certain crimes. So if a person is charged with possession of
methamphetamine with intent to deliver. The range they would face without any felony criminal history is 12 to 20 months. If they, a lot of times a person in that situation who is dealing, but not for profit, but dealing to support their habit, will ask for a thing called a DOSA, a drug offender sentencing alternative. And what that requires, if a dose is granted, is 6 months, up to 6 months of residential treatment, followed by supervision by the State Department of Corrections. I mean, it's good for a judge to have options. We do have these sentencing guidelines. Of course, the purpose of that is to promote consistency. So we don't have one judge in Whitman County giving people 5 years and a judge in Spokane giving people 30 days. I mean, that's the purpose of the guidelines, is to promote consistency. So that's a good thing, but it's also good to have alternatives, to have options, such as a mental health sentencing alternative, which is different from a DOSA, different time frames and so forth. It's good to have options, and there are bases for exceptional sentences sometimes as well. If a judge can go above the sentence range if proven to a jury certain facts. A judge can go below the sentence range in certain situations. But the general, 90+% of cases are going to be sentenced within the sentence range. So what are my thoughts? I think overall it's good, but it's good to have options.
Thank you. Jenna?
Excuse me. I would have to agree with Roger. I think that there are sentencing guidelines out there for a reason, and the judge has, I think, minimal discretion in far as the sentencing goes. So if it's a certain offense, let's say a Class A felony, it's up to life in prison. If we're going to Class B, it's up to 10 years in prison. If it's Class C, up to 5 years. So depending on the offense and depending on the history and the facts of the case, I mean, basically the judge is going to decide what the sentencing is. I think that it would be, as far as any kind of drug offenses or mental health offenses, I think it's important that the judge considers, okay, is treatment an option? And a lot of times you'll get that recommendation from the public defender and the prosecutor as far as what they think should be happening. And I think that with the mental health and the drug offenses, treatment should probably, if it's something that applies to that case, should be the thing that they should be doing. Now, like I said, it all depends on the facts, but as far as the sentencing guidelines, I think it's a good thing in Whitman County.
Thank you. Steve?
Basically, I'll just expand slightly on what Roger said, how the system works. You're sentenced based on your offender score. So if you've been misbehaving and you got a few criminal convictions you pass, like felonies, you're going to be sentenced on a new one. That's going to up your score. So it's a ratcheting system. It goes up as you build up your criminal history. After a certain time, things wash out. The legislature recognizes, hey, somebody's been on a Class C, they had drugs have been de-felonized, but say a Class C felony, after 5 years, you can get it vacated. It washes, it doesn't count towards your offender score if you have no other offenses in the meantime. So it's a ratcheted system, and it's somewhat complicated. I put a calculator on my website if anybody's interested. Want to know what your offender score is, but it'll tell you the range. For example, you kick a cop in the knee, it's 1 to 3 months. It's assault 3. If you have a prior felony, any felony, it goes up to 3 to 8, and so on up the scale. So that offender score, that history you build up, is really critical in how much time you get, and reasonably so, right? The legislators try to address the issue. We don't want people repeatedly committing crime, so we're going to increase the penalties they do. But the range can be quite narrow. Sometimes it can be quite much broader. It depends on the offense. But as far as alternatives, I'm glad to see them. It's been a big change in my practice, especially mental health court. It's been a real help in getting, I think, a proper result, a just result for some of my clients. And I'm glad it's there. I'm glad the other options are there. It's just more pinpointed for the needs of the individual and for the needs of the community.
Thank you. It's now time for closing remarks. Each candidate has 3 minutes to sum up what they want us to remember when we open our ballots and make the mark. We will start in reverse alphabetical order, so Roger begins.
Thank you. Again, sort of happens in a trial. You give your opening statement, you give your closing statement, and a lot of times they look sort of similar. I think what's important to keep in mind as far as my practice is that I've got the broadest range of experience in both areas. I've done dozens of jury trials, handled thousands of criminal cases. I've done hundreds of family law cases and civil cases. I have the broadest range of experience. Again, it's just it's something you can't change, I guess. We can all acquire knowledge. We can all, Ms. Brozik doesn't have as much criminal experience. We may not have different types of experience, but we can all acquire knowledge. But what we can't change is our demeanor and why we're doing this. That's already set in stone. And I can tell you, again, I can remember specific hearings from 13 years ago where I'm sentencing somebody. I remember the name of these people. And again, it's just, why are we doing this? I'm doing this because I care about the outcomes of the cases, period. I want to get the cases right. This isn't the type of job where you show up at 9 o'clock and start thinking about, oh, well, what do we got on the docket today? No, I mean, you're taking these cases home, you're reading them the night before, you're doing a lot of prep, and the more time you're going to spend, the more better you're going to have a grasp of the facts. And that's really what these cases come down to, because you're hearing a lot of the same legal issues over and over. It's not too hard to figure out what's the legal standard in a parenting plan. It's the best interest of the children. But each case is different on its facts. And you've got to have a strong grasp of the facts of each case. I'm committed to putting in the time to make sure I understand all of those cases. I think, again, I really do believe that having experience with people who are at their lowest point in terms of drug addiction, mental health crises, a family law matter where they're facing the possibility of losing time with their children, it really wears on you as an attorney, but it would be easy for any of us, and I respect that Ms. Brozik and Mr. Martonick are running for this position, because it would be easy to just say, hey, I'm going to fade right off into the sunset, but we're all committing ourselves to really help the citizens of Whitman County, and that's what I'm trying to do, so thank you.
And Jenna?
I thought he was.
Do you want to go next?
No, you go right.
I'm sorry.
I'm fine going last.
That's, you should be.
I went first, remember?
That's right. Okay, I'm going to say his full name, and I'm going to say it correctly to make up for this mistake. So this is, you are now going to hear from Steve Martonick. It's a good thing I'm not running for anything. I'm just going to run home and stay there. Steve,
Actually,
please.
that sounds like my Hungarian grandmother, how she pronounced it. Look, I don't think experience is a close issue here. I've been from the Supreme Court on 2 occasions, successful once, not successful at the time. I've been in the Court of Appeals a number of times arguing cases. My proudest case is earning the right of due process for WSU students. Before that case, the Court of Appeals decided there was essentially no hearing. It's just a couple professors, maybe a student, and they'd talk to you about the case, and they'd hear from the witness, and that was it. Now they have a full adjudicative case. You can subpoena witnesses. It's a mini trial. It's protection for the rights of the student. You think of a grad student, who spent all his time and money on his education being kicked out, a month before he graduates. Well, it's no longer the case that they can do that just perfunctory with just a mini hearing and boot. They have to have a full hearing, give them a full redress, and give them a full opportunity to be heard, and with an attorney. So that's a case in my experience with appeals. I think it's important to a trial judge because you know how to frame the issues. I saw, and no offense to anybody in here, but there's a judge down, he's an appellate judge, he heard our trial, or heard our case. Oh no, it was a trial, it was just not too long ago anyhow. He heard that, and the way he conducted the trial, you knew he was aware of where the appellate issues could arise, right? Because he was very careful about his sidebars, recording them afterwards, but everything he made a record, he was careful to see that there was a good record, a sound record, if it had to go up on appeal. And I appreciate that, and that was through his experience as both a trial judge, but as an appellate attorney and as an appellate judge. I've done over 100 trials, I've done everything. I've got 4 homicides on my plate right now. I've got two homicides and 2 attempted homicides. One's going to trial in December, that'll be my 5th one, right? This is not business for, I've been a lawyer probably twice as long as Roger, I think for sure twice as long as Jenna. And I've been doing this, and it's not a place for learning on the job, right? I've got the experience. I mean, you want to look at any objective standard, I've done the civil too. I don't do family law anymore because, I'd rather deal with felons than people going through a divorce. But, I've done everything on that list at one time or another, and multiple times for most of it. So there's really no contest to the experience level here. It's just the time. Oh, sorry.
Thank you, and Jenna.
Do you want me to wait till you get ready? With your timer?
Modern technology, superb. Thank you. Now, Jenna.
Thank you. We talk about experience here, and Roger's been licensed 2 years more than I have as an attorney. I took 2 years off to stay home with my kids, and I think that's really good experience. I'm going to bring that to the judgeship if I'm elected. So if you look at the majority of cases filed in Superior Court, the majority is civil. So 77% of the cases filed in 2023 were civil, 23% were criminal. So not all cases in court are heard in proceedings by the judge. I know Mr. Martonick has a different chart about proceedings. So for instance, there's agreed orders and probates and things like that you have in civil cases that are not hearings in front of the judge, but the judge still has to look at them, they have to make rulings. If you think about the proceedings in the criminal side, a lot of them are procedural. You're looking at first appearances, arraignments, those kind of pretrial hearings. And these kind of hearings, the defendants read the charges against them, an attorney is appointed if needed, bail is set, or the defendant enters a plea. This is very procedural. So if you think about the proceedings in the criminal case, I don't want to downplay the criminal is huge, but a lot of the proceedings that the judge is overseeing is procedural. Now, the jury's going to decide in a criminal case if the defendant's guilty or not. If you look in a civil case, the judge is going to decide. The judge has almost absolute discretion. So in the civil cases, it's huge that the attorney that's going to be the next judge has a lot of experience and has been doing a lot of civil cases, because that judge is going to be making those decisions. So, and last year, 97% of the criminal cases resulted in a plea agreement or were dismissed. There were 6 jury trials. So if you look at the criminal side, 97% are going to be a plea agreement or dismissed. The civil side is huge. So if you look at the civil side and you think about what kind of decisions are the Superior Court judge going to make? Well, if you have a divorce, the judge is going to say, how long are you going to get to see your kids? Whether you receive the family home, whether you get maintenance. In a dependency, the judge is going to decide, okay, are these parents' rights going to be terminated? These are huge, huge decisions that will affect people the rest of their lives. Okay? I'm not downplaying the criminal cases, but I just want to say that it's huge. And as far as discretion, if you or your family member find yourself in Superior Court, it's most likely going to be a civil case. It's going to be a probate, it's going to be a family case, it's going to be a divorce, a real estate dispute, or something like that. And the judge is going to make a decision. Not the jury, it's the judge. And so that's why it's huge that you have a judge that actually has the most experience in civil and family law, which I do, out of all these candidates here. And I think it's really important, too, that the judge knows the law and follows the law. So
Thank you. I'm sorry, but
Okay.
we need to, the library closes in 2 minutes, and so.
Okay.
Thank you, your time was up some time ago.
Okay, sorry.
I want to thank the candidates for participating, all three of them, Jenna Brozik, Steve Martonick, and Roger Sandberg, and all of you for being here to participate. I want to also say there's still time to register to vote. The last day to register by mail or online is July 29th. Ballots have been mailed out. Many of you have received yours. There are a lot of races and candidates on the ballot. I urge everyone to read them carefully. Election day is August 6th. Please don't forget to sign your ballot. Go home safely. Come back for the forums in October. Thank you and goodbye.